from Griselli's. She asked, what are the first steps you make when your children have been removed by DCYF and legal standards not met?
Okay, so let's take a step back once again, because once again, we don't want to defend anymore. Sister, there's nothing to defend. The question I have to you is, did the state have the authority to take your children? Did they have authority to take your children? The answer is no, absolutely not, without a doubt, period. Let me explain to you the reason why here, okay? So the Constitution of the United States is the supreme law of the land. It provides the requirements that every single state must follow, because the only thing that makes America America is American laws. The only thing that connects California to Maine is the Constitution of the United States. Without it, there is no nation, there is no union, because the only thing that creates a union is the Constitution of the United States. So when the United States Supreme Court comes out in 1984 in a case called Roberts versus United States, and state that you have the right to intimate association, meaning that you have the right to have an intimate familial relationship with your child without governmental interference, and your child has the right to have an intimate familial relationship with you without governmental interference, then that means that no government can interfere with your relationship with your child, because if they do, that would be a violation of the Constitution of the United States, right? So, you know, Dakota and I would talk about this the other day, you know, because he was pointing out the fact that a prosecutor in New Hampshire was stating that the New Hampshire Constitution permits them to do this. And I pointed out the fact that, yeah, but the United States Constitution doesn't permit them to do it. And so therein lies the confusion that you guys often find yourselves under, is that when a state enacts its own alternative legislation that diminishes, deprives, or abridges the guarantees of the Constitution of the United States, that is unconstitutional. So if the Constitution of the United States preserved your right to have an intimate familial relationship with your child without governmental interference, bound to exist under the First Amendment, because remember, the First Amendment is extremely important. The First Amendment are all the God-given rights. Everything after that is not God-given, right? Because the First Amendment are freedoms, everything else is rights. So you have the freedom to speak, you have the freedom of religion, you have the freedom of press, those are freedoms, because God will permit you to speak until the day you go home. It can never be taken. Therefore, you have a freedom to speak. Now, the right to bear arms under the Second Amendment is a right. It says you have the right to bear arms. Well, it's a right because God didn't create the gun. What God did do is he gave you the freedom to defend yourself, absolutely. But the way in which you choose to defend yourself is a right that's preserved under the civil rights and the notions of our society. So everything after that is not God-given, but the First Amendment is. And the reason why the Supreme Court made the decision in the Roberts versus United States case that it's protected by the First Amendment is because God made you a mother. God made you a father. Only God can take that away, because until the day you die, you will remain a father or a mother. Therefore, it must be preserved by the First Amendment, because it's not something that man creates, it's not something the state creates, it's something God created. So therefore, no state can take it away, because nobody can take from you something that God gave to you. Never. You will remain a mother or father until the day you die. Now, so I think we got the point across there, that the Constitution of the United States protects your relationship with your child, protected under the First Amendment. Nobody can take it away. So when a state enacts an inferior statute in its provision, in its constitution, that permits the judges or prosecutors or DCF to take away your right to have a relationship with your child, that would clearly be an unconstitutional act, because it violates the rights that are guaranteed by the Constitution of the United States of America. So now we have the issue that I started out talking about in the beginning, that any time a state creates a law that takes away any of the guarantees of the Constitution of the United States, that would be an unconstitutional law. And by the creation of an unconstitutional law, when they direct their agents, being a judge, a prosecutor, DCF, it doesn't matter, when they direct their agents to rely upon an inferior state statute that permits them to breach the obligations that they have of preserving your right to an intimate familial relationship with your child, when they do that, that is a crime. Deprivation of rights under the color of law. And when two or more people do it, now it's conspiracy to deprive of rights. It's also perjury. It's also oppression. It's also extortion. There's all kinds of crimes that exist as a result of what they did to you, unlawfully, unconstitutionally. So now here, so the Supreme Court came out in 1984, Roberts versus United States, and they said that you have the right to an intimate association with your child without governmental interference. Your child has the right to an intimate association with you without governmental interference. Okay, So they said that it was found to be a fundamental constitutional right. The First Amendment are all fundamental. Everything within the First Amendment are fundamental constitutional rights. And that's very, very important, right? Because a fundamental constitutional right is the most important civil right that there is. It's the highest, the most important, because that is essential to the structure and fabric of our society, that it must be fundamental. All the First Amendment rights are fundamental. Speech, religion, press, relationship with your children, family unit, that's all fundamental. Now, when you deal with a fundamental constitutional right, there's only one way that it can be taken away, and that is called strict scrutiny, and it requires the compelling state interest test. Now, with the compelling state interest test, basically what has to happen is that the state has to show that there's absolutely nothing else that they can do but deprive you of that right that's guaranteed by the First Amendment. And 99% of the time, when the deprivation is measured or compared against strict scrutiny, it's determined the state has exceeded the power authority statutorily conferred upon it by the Constitution in their act of deprivation. So the moment they took your child without relying upon the judicial test of strict scrutiny, that was illegal. So there's 4 levels of judicial tests, 4 of them. The highest is strict scrutiny, requires the compelling state interest test. Now, again, the compelling state interest test is that the state must prove that there's nothing else they can do but deprive you of this right. Now, by making that statement, listen to what I just said. They must prove that there's nothing else the state can do, which means that no state court can remove a fundamental right, because the state has to prove to someone else that there's nothing else that they can do, which is why only a court of federal jurisdiction can take away a federal right. If a state could take away a federal right, then that would mean that state is more powerful than the federal government, because the federal Constitution resides outside of the limited or statutory governing limits of a state. So a state cannot act outside of its limited statutory governing limits to abridge the federal Constitution, right? Every day they say, oh, that's a state issue. Go argue with the state. It's not a federal issue. Awesome. Well, if it's not a state issue, how can the state abridge a federal issue? So if it's a state adjudication, it has no authority whatsoever to take away a federal constitutional right, because that's a federal issue, not a state issue. So the state must prove to the federal court that they have nothing else that they can do, and when they do that, they fail. So there's 4 levels of judicial test. The highest is strict scrutiny, requiring the compelling state interest test. State didn't do it in your case. The state did not go to the federal court and say to the federal court, I want to take away this federal right that's guaranteed by the federal Constitution under our state authority. Can't do it. They didn't do it. But the lowest judicial test is what's known as the discretionary test. Meaning the judge can use his discretion to take away a constitutional right. Discretion may not ever be used with regard to a fundamental constitutional right. Never. So the judge, he used his discretion abusively by using the incorrect judicial test to remove something that he had no authority to remove, because he relied upon an inferior state statute that said he could do it unlawfully. So now we have an abuse of discretion. That judge has abused the discretionary authority with which he's invested in law by using his discretion to take away something he has no authority to take away. So to determine abuse of discretion, we want to go to the Circuit Court Handbook, United States Circuit Court Handbook. And in the Circuit Court Handbook, it says that there is a 2-part test to determine abuse of discretion. Okay, 2-part test to determine whether or not abuse of discretion has occurred. First part is, did the judge rendering the decision, did he use the incorrect test? The answer is yes, absolutely he did. I just showed you that the judge was supposed to use the highest judicial test, which is the compelling state interest test, and instead he used the lowest judicial test, the discretionary test, and as a result, yeah, an abuse of discretion did occur. Now the second part of the test is, any erroneous view of the law is an automatic abuse of discretion. Any erroneous view of the law is an automatic abuse of discretion. Now let me tell you what an erroneous view of the law is. That in the judge's legal contemplation, that the lowest form of law, being a state statute, is in legal contemplation superior to the highest form of law, the Constitution of the United States. That would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion did in fact occur. Now, according to Blackstone, anytime that there's an abuse of discretionary authority by any person invested by law, anytime that there's an abuse of discretion, that there's 3 crimes that occur automatically. It's the crime of extortion, because they are compelling a result through illegal means, right? They're compelling a result through illegal means. They are bringing about a result through an abuse of their discretion, okay? That's the first crime. The second crime is perjury, because they made a promise they'd do something and they didn't do it, and as a result, they've already implicitly invited punishment should they fail to fulfill that promise. The third crime is oppression, because what they're doing is they are applying the law unequally amongst different parts of society. That judge made the decision that same day that he's going to permit this person to have their kids, but not you. And that means that the law is being applied unequally by a person in position of authority, which is a crime of oppression and tyranny. So the answer is, sister, they didn't have authority to be able to take your kids. They didn't have authority to do it. And you're exactly the people that I'm fighting for. We are going to get these kids home to their families. We're going to get them the love and support they need so they can heal from the traumatic experiences, because the truth is that for every child that they remove from the love and care of their family, that child now has an 80% likelihood of going to prison himself. This system knows it. This system is creating the very objects that they go out and fight against every day in order to proliferate and profit off the illegal acts that they do. They know this. So the trauma that they create in the children that they rob from their families and the love that they need to be able to heal and grow and become a contributor to society and a member of society, that trauma results in an individual that has an 80% likelihood of going to prison, and we've got to stop this. We cannot permit this any longer. So we need these children to be protected. We need them to be back with their families. We need to get them home. But also you need to remember that every single prisoner is someone's child. Every single one of them was a child that was hurt, that has never been healed, and we look at them as a monster. So what I like to say, and certainly part of my argument is, we have got to stop looking at what people do. Because when we look at what they do, all that we see is a monster that needs to pay for things they've done. And that creates this vengeance-based system that we have in place today. But when we look at what was done to them, long before that crime, as a child, as a husband, as a mother, then we see that something tragic happened to them, and it wasn't their fault. And we could see the reasons why they've done the things they've done, because it changed the trajectory of their life. And now we want to heal them. Now we want to help them, because that creates the forgiveness-based system, the system that heals. Today, we are under a system because we're told to look at these people as monsters. But what we don't recognize is that that monster was created. It was created by the oppressive and illegal acts of this institution right here behind me. And we need to heal those brothers and sisters, because if we can give them the love that they lost in their childhood, in their whatever it was, as a result of a divorce or whatever it might be, if we can heal that trauma, there won't be crime anymore. And there won't be a need for prisons anymore. Because the reason why people hurt other people is because they themselves are hurting. If we can deal with the hurt of our brothers and sisters and get them out of these institutions that's continuing to hurt them even more and enslaving them, so that these assholes behind me can make billions of dollars every single year, and they're forced involuntary servitude, the weakest, most vulnerable in our society, if we can do that, we can overcome this issue. We can overcome the criminalization that exists here in America, and we can actually have a nation of peace, harmony, and love, as we were designed to be from the very beginning, when these people, 243 years, decided that they weren't going to follow the will of the people and instead proliferate this institution that they call prisons, but we call sweatshops. Thank you so much. Thank you.
Thank you for that answer, brother. And I pray that your response resonate with Griselli.